I'm Beverly, and I'm on the witness stand. Hello everyone, this is Beverly. I am coming to you from the great state of North Carolina in the Appalachian Mountains. Okay, I want to recap today and yesterday, which was day 21 and 22 of the Karen Reed trial. And the first thing I need to do is make a correction from my last video. I made the comment over and over about the chain of command. That was incorrect. I know better. I'm so sorry, but it was a slip of the tongue. It is chain of custody. So when I talked about collecting evidence, you know, the red solo cups, you know what I'm talking about. So let's just move right along and get to it. I have my notes here, been watching all day long, and I'm going to tell you that this was a tough one today. I will be the first one to say I don't really like it when we have expert witnesses, because it's always, not always, but a lot of times when it's scientific, it gets really convoluted. So I tried to do the best I could with it, and so hopefully you can learn something, and you know, maybe I'll learn something from you guys. So appreciate the comments. Make sure that you subscribe and you like, and I really appreciate it. Okay, so this guy was continued today from yesterday. He is a prosecution witness. I thought he did a really good job. Let me tell you who he is first. Dr. Judson. Okay, well, his last name is Welcher. So let's just say Dr. Welcher, and he is some engineer, mathematics, whatever his situation is, okay? Different from the Shannon Burgess, who apparently they work together. Anyway, they're colleagues in some way. Shannon Burgess is the one, remember, I told you about, that he's been working on his bachelor's since 2008. And, you know, by now, you would think, but needless to say, he's like this, but he's an accident reconstructionist, okay? He did a bunch of tests, very extensive tests, did a whole lot of math, a lot of physical science. So I started listening to him. I thought he was a good witness for the prosecution, at least as much as I could make out. Then I found out that I really didn't know what he was saying a lot, but one thing popped out. Of all his testimony, one thing made me sit up, and I took a note. He said that in his investigative testing that he determined that the broken taillight did not come from Karen Reed backing into John's car at the house. He showed the angles and the math and science behind the angles, that sort of thing, and he came to the conclusion that it was her back bumper that hit John's back bumper. And when you look at it, I mean, he had diagrams and he had all these things. And when you looked at it, it looked like that's a real possibility. But I don't know, it was so confusing that I figured that whatever the conclusion came from that, it was going to be torn up by the defense. He also did an experiment where he painted blue paint on his arm, and he also, his company, Aperture, I think is the name of it, which apparently they do all these reconstructions, they bought a Lexus, just like Karen Reed's, and they demonstrated or did their demos with it. And so he painted black paint either on his arm or on the car, cannot remember, or maybe both, don't remember. But anyway, they did a test of backing into him. He is the same height, weight. He wore the exact same clothes, same shoes, not John's, but he bought the actual brands and all that. So baseball cap, everything, and had a cup in his hand. And they got a cup or a glass from the same manufacturer that the bar that Karen and John had just left. And John apparently had a glass cocktail, or cocktail glass, excuse me. So anyway, he replicated as much as he could. And then he had somebody back into him at 2 miles per hour. Well, as he even stated, he wasn't going to do it any harder than that, because obviously he didn't want to get hurt. But then he talked about a spinning motion, and this spinning motion could have sent John into the yard. But he also made a comment that Karen did a 3-point turn, which, if all of those things are correct, then I would say, maybe I'll give you that. Maybe she did do it. But I'll be honest, if I was on the jury, I'm going to say that I got a little bit too much science and it wasn't really broken down into lay terms. And I think that when you have an expert witness, that is doing those kinds of things when it has to do with engineering, math, physics, all of that stuff, you have got to break it down to where John and Jane Q. Public knows what you're saying. Because I'm an intelligent person and I'm not comfortable with what I heard today. If I had to make a decision based on what I heard yesterday and today, I don't know that I could do that. And maybe I'm selling myself short. I don't know. So anyway, there were parts of the experiments that Dr. Welcher did I thought was kind of a reach. But then there were other parts that I thought, okay, I think that could work. But anyway, so Welcher said that about 12:32 a.m., which I don't think anybody is really disputing the time, maybe with 20 or 30 seconds, but basically around that time that she did a 3-point turn maneuver that spanned over 50 feet at approximately 74% I wrote throttle. He noted that the SUV reached speeds exceeding 23 miles per hour during this reverse. It lines up with the prosecution's timeline. But I want to ask you, in the best of conditions, when you've done a 3-point turn, have you ever revved the engine up to 23 miles per hour? I haven't. And I just don't see a need. I can't figure out why even if she was mad, and it's snowy conditions, by all rights, everybody has said now that snow is on the ground, however much you want to believe, but everybody agrees around that time it was snowing. So just find it very difficult to think that she would have gotten up to 23 miles per hour. But look, I'm trying to be as objective as I can, but I need the prosecution to prove this to me before I say, send this woman to jail for the rest of her life. So anyway, so that's kind of that. And then the next thing was what I had told you about. He donned the same kinds of outfits, used exactly the same brands of hat, shoes. He used himself as the model because he was the same height and weight as John. Did the blue paint, it was interesting. I thought that made more sense to me. It was more lay terms, so I felt better about that experiment than maybe the rest of it. And if that is true, and she did hit him at that speed, that could have broken the taillight. And if that broke the taillight and his injuries were consistent with the spoiler coming off of the back rear door, that raises up, if that had happened, then I think that the broken taillight at that point hitting him at a significant, whatever significant is, rate of speed, then I could see the prosecution with this. But I need more information. I just need more information. So then he talked a lot about data points that he lined up, very complicated data points, but they used the car's black box, they used internal clocks, they used all kinds of stuff similar to what I was telling you about last week. But one of the interesting theories is that, and I didn't know this, but I guess it has to be a lot heavier impact, but that black box only registers really car impacts. It doesn't really record or digitize if a person is struck by the car. I guess it's not enough force. So, there wasn't a lot of information to be used there. Here's a big one. As if he didn't learn from his cohort, he modified his slides. Yeah, He modified his slides. He has a huge slide presentation, and he modified those. He said that he incorporated suggestions from Brennan, who is the prosecutor, and new data from Shannon Burgess. I never got what the new data was. I'm sorry, I don't know. Maybe I was zoning out during that time, but I don't know what the new data was. But I don't understand. Is this company, is this protocol for this company to make adjustments? I feel like once you turn in a report, then that's what you testify to. But it happened again. And I think that the fact that these two men work for the same company is telling in my mind. But that bothers me a whole lot. So the defense obviously wanted to object to it and wanted to prevent it from coming in, but Judge Beth said no, she's going to let it come in, and accepted or permitted the updated version of that PowerPoint presentation. So, I keep wondering about, are these decisions, again, are going to be points for appeal? But it's my understanding it's very difficult to overturn a decision based on a judge's ruling unless it's so egregious, and I don't think any of these really come down to being egregious right now. So then the defense goes in for their cross, and the defense attorney, Robert Alessi, went after Dr. Welcher so hard. I mean, it was kind of got my chest tightened up a few times, because I didn't know I didn't know who I should feel sorry for, because Dr. Welcher felt like being, I don't want to say combative, but you could say it. But what I thought more than anything was that he twisted and turned, evaded some of the questions for pure meanness. I don't, and I say pure meanness here because I don't mean that he set out to do harm or to cause this man. I think Alessi's probably lost hair over this today. I think that he purposefully, I don't know how to say this, but it was almost like he challenged every little thing, or he would tell Alessi, that's not what I said. And he'd get into such minutiae detail, and after going back and forth with Alessi, I feel like then he answered the question that Alessi asked in the first place, and in the way that Alessi was trying to pull out from him. So I felt like some of that was just unnecessary. But they also talked a lot about the fact that Welcher had concluded that it was a collision with the car that Karen was driving and John O'Keefe. And so Alessi challenged him on that, saying, you can't say that she hit him. You can say that the investigation or his process showed that John might have had a collision with a car, but you can't say that it was Karen Reed that did it. I don't know, I thought the whole point of being there was with Karen Reed. So that was some of it. So Alessi also questioned or challenged Dr. Welcher on the validity of his method. By the way, let me bring out this point. Aperture, the company that did this investigation, testing, reconstruction, they bought a car just like her Lexus, Karen Reed's Lexus, and the prosecution, the Commonwealth of Massachusetts, is paying for that car. Then Aperture is going to turn around, they said, and sell it after the trial. I guess the only way you could replicate is to buy several of them, but at this point, that's an expensive task. So anyway, so he also Alessi challenged Welcher coming up with one scenario but sticking with it, not examining or considering other scenarios. I think Welcher also made a point that you're given this information, you put the information in your data, and then based on what the data gives you, you start forming a hypothesis. And the more information you get is going to lead you into a specific way of thinking. 100% prove anything, but you can say within a reasonable certainty, but you cannot do anything but disprove. So you can said that Welcher was biased in some of his finding, but not like a racial or cultural or anything like that. He was biased toward a conclusion, like he decided that's the way it was going to be, and then he made all of his evidence point that way and wouldn't consider alternative opinions. Now, I told you about the car, that Aperture bought the car. Obviously, the prosecution paid Aperture for this witness. He is definitely a prosecution's expert witness, and let's don't get it twisted. The defense is going to do the same exact thing, but what the defense brought up today was, you're being paid for your testimony. Well, yes, Alessi, yes, he is. Just like you will be paying for your expert witnesses. I think this should just not even be allowed to be brought up in court anymore, because they're accusing the opposite expert witnesses of being biased because they're being paid. They all are. So the prosecution, when the defense starts its case, the prosecution's going to go right back at them with the exact same thing. Okay, I told you about presentation of the PowerPoint being contested, and I for one agree with the defense on that one. I think I don't like when, I didn't like it the other day with Burgess, and I don't like it here today. I want to see if that happens more in this trial, because that really, as I like to say, the 13th juror myself, I think that is shady. And I'm thinking, are you really watching the case and then amending your reports based on what you're watching? I don't know. They swear they're not, but how do we know? I mean, how do we know that the jurors aren't going home and looking at stuff? We don't know. We just have to take their word for it. And isn't that what we're doing with these expert witnesses, is taking their word for it because they're expert? And I don't know, but it's a question. It's a quandary that, I think it bears thinking about. Alessi inquired about the amount of force necessary to cause the injury sustained by O'Keefe. And he wanted to know if a Lexus SUV could inflict such damage. Now, you remember we talked about this earlier, that he looked like he'd had the crap beat out of him. Now, Welcher said, yes, it could, with 300 to 400 pounds of force. There was a calculation that came up with that. I don't know. And he said, yes, that certain parts of the SUV could cause that kind of damage under certain specific conditions. So his court testimony is going to continue tomorrow, hopefully. It'll make more sense that she was getting kind of brusque toward the end, wanting to get this wrapped up. Tomorrow is a half day. They will stop by 1 o'clock Eastern time. I think there's going to be some arguments in the morning that's out of the jury's presence, but we'll see. But now you may step off the witness stand.
I'm Beverly, and I'm on the witness stand.